Meanwhile, Governor of Rivers State, Siminalayi Fubara, insists he is not ruffled by the threat to remove him from office. At a church service to mark the 2026 Armed Forces Remembrance Day in Port Harcourt, Governor Fubara sounded confident that the matter would be resolved. He emphasized that with the continued support of the people and with divine intervention, his administration would overcome the challenges.
The reason why I don't shout, I don't complain, I know what I have. I know that I have what is supreme, and that is God. So I want everyone to be relaxed. What is important is peace for this dear state. And we'll get it by the special name of God.
I want to solicit to all of us that as we have come today to pray for legionnaires, for their wives of the fallen heroes, the husbands of the fallen heroines, please continue to uphold the government of Sir Dr. Siminalayi Fubara and my humble self in prayers. Prayers have sustained us so far, and we believe that prayers will continue to sustain us in the mighty name of Jesus.
Lawyer G.T. Ogunye joins me on the news at 10 for legal perspectives to these developments. Thank you so much for joining us tonight on the news. Now, help us understand the underlying legal implications in this renewed fight between the Rivers House of Assembly and the governor. Do those items listed qualify for gross misconduct?
Well, thank you for having me. Good evening, fellow Nigerians. The tango, political and legal tango in Rivers State has become something that is very tiresome, in terms of even analyzing and discussing it, because it's a recurring matter. And of course, when these matters present themselves, invariably, Nigerians will have to be enlightened about it, and Nigerians will have to be informed about it. We're in a constitutional democracy, and under our constitution, we have three arms of government: the legislature, the executive, and the judiciary. And in their interrelationship, inevitably, those who head these institutions and those who are members of this institution will have recourse to the Constitution and its provisions in terms of affirming and reaffirming, clarifying and reclarifying their duties and obligations under the Constitution, their powers, the limits and ambits of these powers. And so that's what we've seen play out too often in Rivers State. The Rivers State House of Assembly, and I'm not going to dwell on the politics of all this fight, but just the legal implications of what's going on, has the power, indeed the right, under Section 188 of the Constitution, once it receives a notice signed by no less by some members, requisite members of the House of Assembly, or anybody that the holder of these offices, that is the governor or deputy governor, or both of them, are engaged in acts of gross misconduct, warranting that they be removed from office. Once this notice is received, and the House, by a vote of 1/3, support the motion, of course, it flags off the process. Okay. Undoubtedly, therefore, the House has the power to exercise. Of course, we expect that the House will exercise this power with responsibility. All right. And once this power is exercised and communication is made to the governor and to all the members of the House of Assembly, given the particulars of the alleged acts of misconduct, there is expected to be a response to it by the governor or deputy governor, or both of them, as in this case,
Okay.
within 14 days. And then the process goes on like that until it terminates. Of course, the final provision under Section 188 says that what the House considered to be an act of misconduct is what's going to be an act of misconduct in the circumstances. Act of misconduct has not been defined,
All right.
but generally it is believed that it's going to be such grave acts that are deemed to be
All
unconstitutional,
right.
that violate the Constitution, etc., etc.
Okay, so let's also look at the allegations of spending without budgetary approval. Now, didn't the budget presented by the sole administrator and approved by the National Assembly suffice?
Look, what are the facts of this matter? The facts are in the public domain are that the governor in 2024 was in office and spent money before the sole administrator came. The sole administrator spent 6 months, and the sole administrator also left in September. So if you deduct the time or the period the sole administrator was in office from that calendar year, you still have 6 months. So my view, therefore, is that the governor doesn't lose anything by presenting a budget to cover those periods, and then indicate in that budget proposal that, look, during this period, the sole administrator was in place, and his budget was approved by the National Assembly. And for that period, that will suffice. But for the remainder of the period, I think that a budget ought to be presented to cover that. And for the new year 2026, a budget also had to be presented. We don't need to play any ostrich about this or to be pedantic or, just say something that doesn't reflect the fact. So if you ask me, therefore, the House of Assembly has a right to talk about the remainder of those months of that budget year and then the 2026 budget year. Although the Constitution provides regarding 2026 and every other year that there's a window there that before the presentation of the budget, the governor or the executive arm of government, either at the state level or at the national level, can be spending money,
Okay.
Up to a percentage before the presentation of the budget.
All right.
For the illegal year. Yeah.
All right, so let's go in further now. The state lawmakers have alleged the governor may be going to court to stop the impeachment process. How valid can this move to stop an impeachment, the impeachment proceeding?
Under Section 6 of the Constitution, the judiciary that is thereby created is open to the governing and the governed. And I'm talking about access to court, access to justice. It doesn't lie in the mouth of the legislature to decry any such attempt. The court is wise enough, the court is knowledgeable enough to shun the abuse of its process. This is my fundamental assumption. So if the governor or anybody approaches the court to truncate the process, the court should be knowledgeable. The court would be knowledgeable enough to throw out such an abuse of court process, because it's a political process, and the Constitution does not expect that midway somebody would dash to court to ask for another, to truncate the process. The jurisdiction that is exercised by the judiciary, our court, in respect of impeachment proceedings, is usually a jurisdiction of judicial review, meaning that it is when the whole process has been consummated that the court can now review the matter,
Mr. Aguye,
and then declare whether that matter is constitutional or not. The court is not expected midway or while the process is taking off to dabble in it to truncate it. That's not
Okay.
the expectation of the Constitution. That's not the intent
All right.
of the framers of those sections.
So still staying with the impeachment now, this is not the first time that Governor Siminalayi Fubara has faced impeachment moves. And some people are saying this one in particular is a waste of time. What do you think of this?
Come again, please.
This is not the first time Governor Fubara is facing impeachment moves. And some are saying that this particular one might just be a waste of time. What do you think of that?
No, I will not thereby speculate. I know that the last time there was a political intervention, the state of emergency came, just as the parties were saber-rattling and there was tension in the state, and it was said that law and order was on the verge of breaking down, and that saved the day. And the governor himself had come out to declare that he would have been gone if the president had not intervened with the state of emergency to save him. I do not suspect or imagine that the governor or the president would declare a state of emergency again, except the conditions that warranted the declaration of state of emergency last time, research. And even at that, when the last one was declared, there were a lot of controversy and there were a lot of argument as to whether, the constitutional threshold for declaring a state of emergency had been reached. But I do not imagine that the president will again declare a state of emergency to save the day for the governor, as he said the last time. Therefore, I do not imagine that anybody, who is following the event closely will say that, oh, this is just another tool of harassment. It will not achieve anything. It's a constitutional process. And my view is that regardless of the fact that a lot has happened in their political party, between that time and now, the governor had defected. The members successfully are defected. All of them are the same political party now. They were also in the same political party the last time, so to speak. So if there are good grounds and solid grounds to proceed, and the members of the House of Assembly are not using this just as a tool of harassment of the government, I think that it's very likely that the process may go on, and ultimately, there could be a panel that will be put in place by the CJ of the state to investigate the allegations against the governor. They have 3 months to do so. So what is going to happen between now and the 3 months, assuming the process go on to that stage?
All right.
Your guess is as good as mine. But generally speaking, impeachment proceedings are very cumbersome, and I think that they are deliberately made to be so cumbersome by the framers of the Constitution. In the Second Republic, it was only Barab Musa that was successfully impeached, and that was also contentious. The one against the monarch of Ibadan now, was reviewed successfully by the Supreme Court and nullified.
All right.
And I'm talking about Senator Rashidi Ladoja.
All
so
right.
It's not something that is very easy to consummate and achieve.
Titi Ogunye, lawyer, thank you so much for talking to us and giving us your perspective on this. Thank you.
Yes, it's my pleasure.